genuine conversations with unique minds on the threats, the complexity, and the geopolitics shaping our world. This is the Entropy Podcast with Francis Gorman.
Hi everyone, welcome to the Entropy Podcast. I'm your host, Francis Gorman. Before we dive in, if today's conversation challenges you, sparks a new idea, or sharpens how you think about the world, don't keep it to yourself. Subscribe, leave a review, and share this episode with someone who enjoys staying curious. Today I'm joined by Darren Bender, a practicing attorney based in Texas and a chief legal officer and co-founder of ProTech, a post-quantum cryptography advisory services company. His career bridging IT and the law helped him create the post-quantum negligence framework, which helps organizations navigate their cryptographic evolution by making informed decisions in the best interest of the company, both for protection and profit. Darren, it's lovely to have you here with me today.
Hey, Francis. I'm excited to be here to share the views and opinions that are my own and do not necessarily represent those of any organization that I'm associated with, that are for educational purposes only and do not create an attorney-client relationship between ourselves or anyone listening today. Super excited to be here.
That's great, Darren. After that intro, I feel like I need to sign a waiver or something. I know we're in for a treat now. Can we unravel what led you to the point where you became a co-founder of a startup in the quantum space? Because your career arc, when you look at it, goes law, IT, and now all of a sudden you're at what I would call the front face of legal considerations around quantum and negligence and how organizations should treat quantum so it doesn't burn them in the future. How did that happen?
Yeah, it's been a journey. The IT and law gave me an edge when the topic of post-quantum cryptography was put on my table. It came up last year while we were working on our capstone to get our MBA. One of your previous guests, Tim Williams, put it in front of us to choose, and it came down to bakery and post-quantum cryptography advisory services company. So it was delicious cakes versus something that had a little bit more of a chew to it. Needed a bit more of a refined palate. But it's a complex topic. It's got a real flavor to it. Kind of bites in the front end, but it's got a real nice taste in the back end. Kind of a carroty taste, is how I would describe it. So notice the landscape was very cybersecurity, technologically heavy. So the barrier to entry was, I'd say it is high for someone that lacks an IT background or familiarization with tech. So I had that going for me because my IT background lent itself to understanding the landscape and then adding some legal flavor to it, bringing my own spices.
Darren, I suppose I have to ask because hot off the press in last week, Donald Trump has signed an executive order that has essentially shifted the timelines. When we think of your framework, does that play directly into the negligence aspects that a company needs to consider right now, especially in the US, if the president has mandated that, quantum readiness pulls back to 2030 and 2031, depending on the use case?
I'd say that it does. It absolutely does, because it makes the issue hard to ignore, to claim ignorance in any kind of reasonable way. To ignore it at this point would that lends itself to a view that you'd be having conscious disregard of the issue. Before I dive in too far into the legal impacts, I did want to set the table because, having followed your podcast, you've had clandestine services, you've had some specialists from cybersecurity. More recently, Louise Davey, who gave me a shout out. Thank you, Louise. Really appreciated it. Who was talking to the boards, and I'm excited to add legal to the table. But I'd like to take a minute and set it a bit because I had that IT background going for me. But if there's a lawyer out there who's listening for the first time, who's picking up this podcast, like, oh, lawyer, let's see if I understand what they're talking about. I can imagine folks. I like to picture it like home style. home style is everybody brings a little bit, and you take what you want. Before you sit down and eat, you take some stuff that's familiar, you take some stuff that's new. When everybody's got a plate, they sit down and they have a nice conversation. So I could imagine, oh, what'd you bring? You got some cryptography over there? What's that about? Cryptography. That's like WhatsApp. You have a message, you send it to someone else, and while it's in transit, it's all garbled up. People can see the message going by, but they don't understand what it's saying. But you get it and you can read it. And that's fine. That's cryptography. What's the law? Oh, the law. That's like entropy versus order. There's man is free. Man is born free. He wants to do what he wants. Everybody gets to the intersection. They all want to go first. If they all go first, though, they all crash. So law adds some order to that with four-way stops, roundabouts, traffic lights. You kind of balance the freedom with the order. That's what law brings. Well, what's that? The quantum computer business. What's all that? Like, oh, that's that could break that message. That message that's going by, they could read it in real time, or they could read it later. If they harvest it now, they could decrypt it later. That's like, oh, could that apply to my bank account, my anything else that's secure right now that might be encrypted? Am I using that right? Yeah. And then they have a talk, and then they chat. And what might come up is negligence. What might come up is regulations and fiduciary duties. So the regulations, with this executive order that came out, it puts it on the radar. It applies to the federal government, federal agencies, and arms organizations that come in contact with the agencies, as well as certain critical infrastructure entities as well. It still doesn't explicitly apply to the private sector, like bakeries or banks or hospitals, but it's starting to show what the floor is as far as what's reasonable. It doesn't set the ceiling, but regulations do set the floor. And it's an executive order. So in the United States, our executive orders, they're put in place by the executive branch. The leader of the executive branch is every 4 years, we do an election cycle, and we have a new leader of the executive branch, or they can stay for up to 8 years. There's a chance that when the next one comes in, they'll erase the executive order. So it doesn't have quite the endurance of a law, something passed by the Senate and Congress working together and then approved by the executive branch that goes into law. But it's still a sign that this should be on your radar, whether you're a private company or a public one, working with the government or not. This is a sign of what it's reasonable to know versus not know. And it's a sign that post-quantum cryptography is something that is becoming less and less reasonable to say, I never heard of it.
By the way, Darren, I absolutely loved that bringing it all together in non-technical language. I need to bring in people who've been on the outside of this problem more often and have then come into the room, because you added a bit of flavor to it there that I haven't got before, which is great. So thanks for that. That's very much appreciated. Let's pull at the negligence piece a little bit. So let's role play. I'm in court in 2032. There's been a harvest now, Decrypt Later incident somewhere in the past decade in my organization. What are the first 5 documents plaintiff's counsel asks for?
Oh, okay. Plaintiff's counsel, they're going to want to see your governance. They're going to want to see what the board considered, how they came to their judgment, how they implemented their plan, when that governance started. It's all going to rely on governance. So I'd say they're going to look at the minutes. They're going to look at the resolutions, the board resolutions. And they're going to see what was minuted. They're going to see the topics that were considered. They're going to see the information that was considered. They're going to see who presented the information as far as the officers go, reporting up to the board. And I don't know that I'm going to have a 5 list here, because it's going to be what the office, let's see here. All right, let me try and count. Officers, the officers are going to be fed up by the branches of the organization that they are in contact with. So the technical side is going to want to present an inventory. All right, did you do an inventory? And did you identify your crown jewels, the most important things? The plaintiff attorney, I don't know what data was harvested, if it was a top priority item or not, but they're going to look and they're going to see if their client meets the list of, oh, they did bank account numbers last. They decided to secure the bank accounts last. They decided to go with just customer address, name, and social security number and phone number, things that were breached in a TransUnion breach years ago by several different companies that are accessible on the dark net for the low price of some crypto. But the account numbers, that's something that should have been a higher priority. So they're going to look at governance, the inventory, and then they'll look at, okay, how did you decide on your migration plan? What's reasonable? And did you take reasonable actions to protect the plaintiff's client? The way that they'll get there is they'll try and check all the boxes on the negligence framework. So you've got duty, breach, harm, causation, breach. The breach will occur whenever the data was harvested. So they're going to look at what you calculated to be the data shelf life. How long did that data have value? If the case is in 2032, then that data, if the shelf life is longer than 6 years, it would say, oh, you should have prioritized this pretty high, because if you don't finish by 2032, let's see, if you don't start today, that data is already valuable. It wouldn't matter if it takes 6 years just to migrate, and the shelf life is 6 years. Well, that puts you 12 years out. Doing this math in real time is tricky. So they're going to want to look at the math that you did. This kind of drives home the point of they want to see how you calculated your data shelf life, how you determined what your migration time would be by talking to your internal resources in cybersecurity, external resources. There are specialists, cryptography, from what I understand. It's a small amount of folks that are qualified to take on a challenge like this. So who did you talk to? What did they say? And what were these things that you considered when you were deciding to act, when to act, or choosing inaction? And again, cryptographic procrastination. They'll be looking for that too, because one thing you may do is just ignore it. And that's something that the plaintiff's attorneys would be hot to notice.
Sorry, I put you on the spot there, Darren, and I made you do some math in real time. So apologies for that. That's on me. But I think the struggle of trying to pull that together kind of unearths the complexity. There's so many moving parts here. You know, what was the high value target? What was the exposure level? How do I determine the shelf life of that data within that life cycle of that system? Does my migration time equate to longer or less than the value of the data in the life cycle of the system? Like, all of these different nuances kind of wrap around each other. So you can see how this gets complex. So if I'm a board member listening to this right now and I'm starting to do the maths, I don't know the technical outcomes yet. I have it in the back of my mind. This may be a problem. And I know that we're not going to fund our post-quantum budget in 2026. What should the board meeting say? What's the minutes you pick up and look at and go, this was a practical decision, or this was negligence?
Okay, so 2026, the board is meeting to decide what to do. Should we act now? Should we delay? What's this look like for us? I would pick up the Mosca theorem. The Mosca theorem is very helpful. One of your previous guests created it, Mr. Mosca himself. It's an elegant formula that boards should be able to grasp and document that they applied it. X plus Y is greater than Z. If X, your data shelf life, plus Y, your migration time, the time it takes you to migrate to post-quantum cryptography standards, is greater than Z, Z being the date upon which a cryptographically relevant quantum computer, the kind of quantum computer that can break that encryption, break those secret messages that are going from one place to the other, comes online, you're too late. If X plus Y is greater than Z, you're too late. So you want to try and be not too late. You want to be on time. So if you're a health organization, you've got HIPAA compliance in the United States that requires you to retain medical records and keep them private for 20 to 30 years out. That's a long time. And it's likely that it's too late for you to keep those records secure before a cryptographically relevant quantum computer comes online. And one of the things that courts will consider is whether it's even possible for you to achieve that privacy. They will take that into account. So it doesn't mean, oh, we're too late. Forget it. We're done. 20 or 30 years from now, it looks like there's a 99% chance that there's going to be one of these cryptographically relevant quantum computers. They're going to see all our patients' most private medical data. And that's that. Oh, well, it's do what you can. Start now. Still start right now. Still prioritize. Find out which health records and documents, or if you're a bank, which accounts and services need to be protected. It's about identifying your crown jewels and moving forward in a way that makes sense, that shows that you made an informed decision in the best interest of the company, and that you took reasonable action to protect from a reasonably foreseeable harm. Another thing that they're going to want to look at is what's published by the Global Risk Institute. Every year, at least the last couple of years since I started watching, they publish the Quantum Threat Timeline Report. Now, this is a collection of about 30 experts regarding quantum computers, and they ask them to estimate in 5-year intervals, 5 years from now, 10 years from now, how likely is it that there's going to be a cryptographically relevant quantum computer online, 15 years, all the way 30 years out. As those percentages go up, you have to take that into consideration. So one more formula for you. And to touch on the math, the lawyers involved here, you'll hear this from attorneys regularly. It's partially true to me as well, but we get into the law. A lot of us say we get into the law because we didn't want to do math. We want the words. Give us the words. Give us the ideas. Keep us away from the numbers. So keep that in mind as I'm going through this. It can be done. It can be done. You might want to do it. Get your pencil and paper out. But give it a shot. The learned hand formula. So the learned hand formula it's based on U.S. case law. There's a case from the 1940s regarding boats, but that doesn't matter. Effectively, it's an economic reasonability test. Also an elegant formula, B is less than P times L, where B is the burden of preventing a harm, like migrating your cryptography to post-quantum cryptography standards. If you want to make sure that that's less than P, the probability that harm will occur, times L. L would be the magnitude of loss, what's associated with medical records getting in the hands of nefarious actors, or customer information from banks getting in those hands, or the account numbers themselves, where real wealth can be stolen. If the burden of migrating is less than the probability or likelihood times the magnitude of loss, well, then that burden is reasonable. Here I can use some math that I'm familiar with. Let's say a bank has $500 million of anticipated liability or exposure, and there's a 1% chance of a cryptographically relevant quantum computer coming online, and there's a $100 million burden to do post-quantum cryptography migration. All right, so $100 million to migrate. That's less than 1% of the $500 million exposure or liability, because that's just $5 million. 1% of 500 million is 5 million. I took a second to check my math there. Now, 5 years out, 10 years out, well, 10 years out, with the most recent report that was published this March 2026, based on a 2025 collection of data, the new 10-year estimate is closer to 50%. All right, so there's 50% likelihood that a cryptographically relevant quantum computer is going to be online in the next 10 years. 50% of 500 million. Well, at that point, 10 years out, you've got a foreseeable risk of $250 million exposure. Well, that's significantly greater than the $100 million that it costs to migrate. Now, these numbers that I'm using, they're not necessarily like the standard, the industry standards or the expert numbers. They're used to provide an example. There's more simple numbers, round numbers with clear dates, 1 year, 10 years. But the example holds. That's what I would combine. I would have that board do the math, taking the Mosca formula, getting the cryptographically relevant date by which they need to have their migration done, taking into consideration their data shelf life, cross-reference that with some expert opinion. The quantum threat timeline report is one, but there may be others. If you want to go get an expert or your own legal counsel, please, I encourage everyone to do that. And then you can use that to plug in as the P in the learned hand formula, which again, it's United States case law, but essentially it's an economic reasonability test that can be useful for documenting your governance and what you use to make how you made an informed decision when making your final call as far as whether to act now or wait a little while.
Makes a lot of sense, Darren, and it's when you start to break it down in the way that you do, bringing in the timelines, bringing in the cost of migration versus the cost of inaction, etc. You can see how this could play out in the courtroom in the future, and yeah, that's probably it's pretty food for thought for some people to consider as they make decisions going into the next number of years on how they treat the quantum threat. Can I ask you, Darren, what sectors do you think will be the first to kind of fall into the post-quantum negligence space? What will the first ones you start to see litigation against, or is everyone on an equal playing field here?
I think it's going to be the financial sector. I think it's going to be a combination of a couple things based on how cryptographically relevant quantum computers come online, because it's theorized that it's not going to scale very quickly. So they're going to be very selective about the targets that are hit. Probably going to start with governments, which are often sovereign entities immune from negligence claims. Even if a judgment's awarded, they're not required to pay. You're going to get to the private sector, so banking, healthcare, the energy sector, and I see banks as the biggest target because Louise mentioned talking about OT. When we're talking about trust now, forge later, she's got that elevator example. You can almost feel it; it's visceral. Somewhere out there, there's something in the air that can be used to take control of elevators and drop you from the top floor down to the basement in a very unsafe way. That same kind of approach can be used to hack into bank accounts. You log in, you do your online banking. Excuse me. You do your online banking. You've got your password and your user ID, and the bank knows it's you. Part of what cryptographically relevant quantum computers can do is they can decrypt all that password and all that information and provide it so that the bank thinks it's you. The bank thinks that this is an authorized user. I will give them all of their money. So we're talking about not just your checking account. We're talking about real wealth, retirement funds, pension funds, 401ks. Generational wealth is going to be at risk. And I mentioned the Mosca theorem. I mentioned the quantum threat timeline report. I've mentioned the learned hand formula. There's an element that was introduced by Jaime Gomez Garcia into the mix: cryptographic procrastination. The earliest reference I could find for him bringing it up is a quick little detour here of why I think it's so valuable to set the table for a wide audience, because you just never know who's going to come up with, oh, this is a delicious piece of information I'd like to share with the group. He overheard some guys talking about cryptographic procrastination, just kind of having their own water cooler talk. And he's like, "Oh my goodness, what'd you just say?" Like, we call it cryptographic procrastination. Some of these folks, they know that there's an issue, but they're not even thinking about it. They're not making informed decisions. They're deciding, they're choosing inaction. They're just, we got other stuff to do. We've got some clearly profitable things with minimal risk that we just want to go focus our attention on. We'll put this off till later. He took that and said, "Hey, you mind if I mention this? I want to consider how to use it," and introduced it into the Mosca theorem as what's been called the augmented Mosca theorem, published by F.S. Isaac, November 2025. It's the first copy I saw. It's essentially the Mosca-Gomez theorem at this point, but he adds cryptographic procrastination into that mix because as a practical matter, you've got your data shelf life, you've got the time it takes to migrate, and then you've got the time you wait to even think about doing this, thinking about it, or just putting it off as a lower priority. What attorneys are going to look for, plaintiff attorneys that are looking for negligence acts, they're going to look for a few things. One of them is going to be folks that knew but just had a conscious disregard, or should have known and just had a conscious disregard. Another thing that they're going to look for is low jury sympathy and deep pockets. So that's not your mom and pop bakery, going for 20, 30 years, beloved by the community. That's going to be I want to be very careful about how I say this, but banks are not known for being jury fan favorites. But they are known for having pretty deep pockets. You put all that together, if there's a financial institution out there that is not acting now, not documenting their decision, coming to some informed decision and making, even if it's to choose not to migrate, the ones that are just doing nothing right now, I think those are the canary in the coal mine. Those are the ones that are going to get bit first. And that's the sector, I think, that's most at risk because of all these things that are in play related to post-quantum cryptography and then just the kinds of people that you have success going after.
There's two questions you've triggered for me now, and one is European paper trail, because I'm thinking DORA. And I'm thinking, does that make EU financial institutions safer, or does it simply create a clearer paper trail for enforcement and litigation? Because you've got to create all of these artifacts around DORA compliance. I'm just thinking, is that a minefield? Like when it comes to this side of the picture, which is obviously a unique perspective on quantum?
Yeah, it's a minefield or a treasure trove, depending on what perspective it is. So it's a minefield if your compliance and your paper trail is peppered with inaction and poorly informed decisions. It's a treasure trove for, I guess it depends on whose perspective. Hold on. It's a minefield for you, the institution keeping the paper. It's a minefield if it's peppered with all these unreasonable things, just not taking a reasonable duty of care towards what's a reasonably foreseeable harm. It's a treasure trove for you if your paper trail documents informed decisions every step of the way, that you started your inventory, you identified your crown jewels, that's who you began with. You've done internal assessments with your own cybersecurity team to determine what can we handle internally, what do we need to farm out to the vendors that are providing services in this niche area. If your paper trail documents that, treasure trove. From a defendant, like I'm defending against claim perspective, minefield otherwise.
Okay, so that answers that question. We'll put that one to bed. So if you're doing your DORA work, make sure it's up to scratch, or Darren will be coming for you in the future, I think. Darren, I have to ask, for a lot of institutions now, they have a lot of third-party dependencies. They're sitting in SaaS providers or IaaS providers. They've got third-party payments processors, HSM vendors, certificate authorities that may be outside their control. When you look at that landscape and that mishmash of technology, where does the PQC liability actually sit? And what I'm pulling out here is, in the back of my mind, shared responsibility model is screaming somewhere, kind of going, where's the shared responsibility in this picture?
It's all throughout. It's all throughout. Every aspect of the supply chain is going to be brought into a suit because they're all going to look to each other to get their own claims as indemnified as possible. So if you're in charge of a client's data and you farm that data protection out to a vendor who uses a cloud service provider who bought their hardware security module from another vendor, every step in there is going to be looked at. And the biggest kicker here will be joint and several liability. So all that has to happen is the harm is measured, a judgment is awarded, and then the plaintiff who sued to recover for their harm can go after any one of the co-defendants from the supply chain to collect 100% of the awarded judgment. That's how joint and several liability works from a plaintiff perspective. You can go after the deepest pocket, even if they're just 1% liable. Now the judge will allocate liability, and that's going to take a deep dive. That's going to look at everyone's governance records. It's going to see who did what, who really worked to meet their duty in a reasonable way to protect everyone that's part of this supply chain and that they come and interact with. And that's going to take a deep dive. But where that's really going to bite is going to be at the contribution phase, because the deepest pocket, who may have been very responsible and only attributed 1% of the liability, they're going to want to collect. If they pay out the full 100% to the plaintiff, they're coming after that 99%. They're going to want that full contribution from all of their other co-defendants. So it's going to be an internal struggle that's not inexpensive and not quick.
Yeah, if any of this plays out in the future, I'm going to be watching my popcorn and absolute fascination to see where it all ends up, because it's so deep, it's so complex, and it's so intertwined as you explain it in that way. So that kind of makes me ask: is there something that procurement teams, if we go back to setting the table, what should procurement teams be asking vendors in 2026 that they may not be asking at the moment?
Well, right now they're looking at it from a technological risk perspective. So procurement is looking at it through the lens that they've been provided. And right now it's very technologically skewed. I think what procurement may want to take into consideration are the views from other folks outside the cybersecurity realm. So legal, for example, the legal exposure. They may want to look at the chief financial officer and his purview or her purview, so that they get a feel for, all right, part of this effort, it sounds like, is going to be software and part of it's going to be hardware. When it comes to hardware, the hardware that we have, is it able to take on this post-quantum cryptography, or are we going to need to upgrade our legacy systems? There's the box in the corner, the magic box in the corner might not be magic enough for this next pursuit. With chief financial officer involved, part of their duty is going to be thinking about it from a write-down perspective, from what tax credits or deductions can we get to offset the cost of upgrading our systems to the new stuff that can handle these new algorithms. They even get marketing involved too, because when procurement is out there, right now, they may have a lot of vendors who are very eager to answer the phone. The market is filled with folks who are looking for their first use case, who are looking to provide their service or their product. And it's pretty competitive. So procurement may have a good time negotiating, getting custom solutions. 5-10 years from now, you wait, you may find a different environment. You might find panic premiums, and you're choosing off the menu, and your menus are limited to whoever has time to take your call or return it. It might be going to voicemail at that point. The other aspect would be marketing. Marketing could weigh in here but I'm going to hold that one. It's not as closely related to procurement, so I'll wait and see if that comes up another way. Procurement wants to take a bigger look, loop in legal, loop in financial to get a real perspective of when you're trying to choose not just who can do it, but who do we have to choose from? What are the current pricing models? What's our current legal exposure? And can our legacy systems handle this? And is there some other opportunity to offset these costs of upgrades?
I have to ask, because of your makeup, you're highly curious, and that led you to exploring post-quantum, coming up with the negligence framework, talking about the learned hand. Is there anything that's floating around in that mind of yours that you want to share with us that, you know, is percolating there, but you haven't fully formed your predictions on? Have you got any special sauce in there you can bring out for the table?
I do. Fiduciary duty is one of those things that can be hard to explain, not have a real grasp for. So I've been thinking about it a couple different ways. One of them is like a parent and a child. The fiduciary duty is the duty of care, a duty of loyalty, and there's another one also. It doesn't get as much airtime, but it's the duty of oversight. And we're talking about in the best interest of the company, making informed decisions in the best interest of the company. But you're talking about care, and you're talking about loyalty and oversight. An easy analogy to wrap your head around for a long-term problem, like PQC migration. This isn't a light switch effort. It's a long fuse with a big boom at the end if you don't do it right. You've got a child. You're a parent. You have a duty of care, and you have to take reasonable actions to avoid reasonably foreseeable harm. So you don't leave your kid in the tub and walk out of the room. You don't leave your kid in the back seat on a hot day and go into the store and do your grocery shopping and come back out. There's some reasonably foreseeable harm associated with that. You also don't limit yourself to just what people are telling you. You look to what your neighbor's doing. You look online and see like, oh, okay, so over here in the U.S., it looks like we primarily use disposable diapers. But over in Ireland or the EU, they use cloth diapers. It sounds like that might be better for the environment, better for the child. I wonder if I should give that a try. You look to see what the industry standard is. You talk to your neighbors. One of the reasons that the directors are the board of directors is because they have that certain extra link and connection. They're supposed to be the ones that have the bigger picture and can make the connections that it's not in the purview of other people to be doing necessarily, or that they don't have the ability to do it. So if over in the EU, they have just got brand new regulations that say, oh, we got this looming danger and you need to do this for your child to help protect them from it. Over here in the US, whether the regulations exist or not, as a parent, I'm like, oh, over in the EU, they really do. It's just like there's this danger. I need to, inform myself about this and see if I'm going to take care of my kid in this same way. Loyalty, same thing. Your kid grows up, starts playing soccer, football. You see him on the pitch, and who are you cheering for? The opposing team, the neighbor? You're cheering for your kid. You're cheering for your kid, your kid's team. You're loyal to your kid, and they're making decisions in the best interest of their kid and their company. So there's a parental aspect. I'm still kicking it around. Vaccines, you see these looming threats. They're invisible and they change year to year. Well, that's kind of like cryptographic agility. You've got this virus that's out there. It's invisible. You can't see it. And it's evolving. It's an evolving threat. So right now we've got NIST standards. They're approved. They're approved for right now. We think they're good. But 5, 10, 15 years from now, once one of these cryptographically relevant quantum computers comes online, they might not be good enough. They might become vulnerable to attacks. So you're going to have to upgrade. You get your vaccine every year for evolving threats. The flu virus would be a good example. Same thing with cryptographic agility. You need to be able to upgrade, to inoculate your system with the most current algorithms that come out over time, that evolve with the evolving threats. I got another one that involves Hodor from Game of Thrones, which is I think I'll write that one out. I'll save it. But then the last one I would mention is Pink Floyd. I recently was interviewed, and I had a different version of the home style thing. It was Wizard of Oz related. That a chief legal officer, a CEO, or a chief financial officer, a chief marketing officer walking into the conversation right now is like walking into the middle of Wizard of Oz. All you see is this colorful young lady with her colorful companions and some flying bat monkeys. It's Technicolor chaos. It really doesn't resonate unless you see it from the beginning and follow the story where it's spelled out in black and white, from the get-go. And then, but one of my favorite fun facts of Easter eggs is Pink Floyd, Dark Side of the Moon, which, if the starting gun for you is that third lion roar, you start that Dark Side of the Moon with Wizard of Oz, and it's like a soundtrack. You turn off Dorothy and the lion and the Tin Man. You don't want to hear what they have to say. You listen to Pink Floyd and the guys, and they it's great. And when it gets to time, something resonates about cryptographic procrastination and regulations as the starting gun. There's one lyric that just rings out. I can't get it out of my head. It's like an earworm, and I love it. I love the song, so it's great. But it's life is long and you are young, and there is time to kill today. But then one day you find 10 years have got behind you. No one told you when to run. You missed the starting gun. And you run to try catch up with the sun, but it's sinking. I mean, that's the starting gun. Can be regulations. It can be HNDL now breaches. The point is, don't waste time. Like, you're going to miss the starting gun. It's already gone off. Like, get moving, and avoid those panic premiums. Avoid the rush, and everything goes with it. Panic premiums, negligence, exposure, unnecessary legal liability, all of that. So. Those are the extras that are kicking around.
I'm so happy I asked that question now, Darren, I have to say. So, Darren, that's brilliant, absolutely brilliant. So it is. And look, again, great flavor, great visionary. It just, brings it together. I think when you add the quirky into the scenario that's already complex, it kind of brings it to life in a way that's more natural. It's more translatable, I suppose, to people. They can visualize what you're saying, how you're saying it, and the implications of not taking action. So it's powerful. It really is. Darren, before we finish up, is there anything that you're kind of going, why didn't he ask me that before we leave? I feel like I have to give the floor to you one last time, just in case I've missed that killer question that you've been egging to get out there, but I've left it on the table.
I'm glad you asked. First of all, if you do want to hear the Hodor take, maybe we can hang out a little bit after. We can connect another time. But when I think about the home style, and I think about the importance of bringing everyone to the table, making everyone feel welcome, making sure there's enough chairs for everyone to feel welcome. You've been so really an inspiration. I think that you should get a lot of credit for the effort that you're putting into to what you're doing. I don't know if this is just a hobby for you or what, but I've been following along since. You were there in my PQC infancy, so to speak. So this podcast and your messaging and the way that you've been just. You touch so many aspects of cybersecurity and just life, and the way that you weave it all together with your guests, the questions that you ask and the responses that you evoke. I think your show, your efforts are kind of a metaphor, an analogy for the best way to approach this issue, which is we need more people talking about it. We need to make more people feel comfortable sitting down to join the conversation, and it be very excited to see what more people have to say.
Darren, I really appreciate it. That's lovely and really kind of you to finish up on. thanks for coming on. You've been a great guest, super insights, and I loved having you on the show.
Thank you, Francis.
Thank you.